And we have our lovely Joanna, who's joined us today, and she'll be talking about the legal component of our course. And just a heads up, Satish Babu will be speaking about cryptocurrency, blockchain, and fintech coming up on next Monday. Bill George will be talking about IDN and international domain names. And lastly, Javier Roa, who is now the incoming CCNSO representative with ICANN, will talk about small island states. So, Joanna, maybe you can introduce yourself while I add up the next slide. I'll add the next slideshow.
Thank you very much, Glenn. This is Joanna Kuleska. It's lovely to meet you. Thank you for taking the time to join us in a lovely Central European afternoon, but I understand that the timing might be challenging to some of you. So thank you to those of you who have found the time and opportunity to join us live. I'm looking forward also to the recording being distributed to those of you who could not make it due to different time zones that the school provides content for. I wanted to thank Glenn and Alfredo for the introduction to speak to you here today about legal aspects of internet governance. As you might imagine, that is quite a broad topic, very comprehensive. We just have 1 hour. What I thought might be fun would be for us to look at certain specific issues that seem up to date when we look at the way that the internet functions, and try to pick your brains and see what you guys think in terms of the law that would be applicable to those specific situations, as well as try to start us off thinking about how law could be applied to internet governance and everything that internet governance connects with. So just a very general disclaimer, I will not give you a very comprehensive look at law online, as that would reach far beyond the hour that we have reserved here. I will rather instead look at specific selected issues. Thank you for displaying the initial slide, Glenn. As you can see here, I work at the University of Łódź, which is in Poland. I work at the Department of International Law. Hence, bear with me, there will be some discussion on international law as well. And I have the opportunity to represent European end users within the at-large advisory committee of ICANN, which I believe offers a perspective that might be of interest to the participants of this course. Just to start us off, what I appreciate at events like this one is that we get a wide range of participants coming from different backgrounds, from different disciplines. What I have found to prove quite effective was to try and get you thinking about law as such. We all have an idea, we all know more or less what law is, but then for us to better understand what it is and what it is not, it usually makes sense to try and think where law comes from. So was this an interactive exercise? I would query the group we would have in the room to try and find out what you guys think law is and where it comes from. The pictures you can see here on the slide are sort of revealing. There are different approaches to law. There are different understandings about the reasons we have law, where it came from, and what it means. Just to get you thinking about law, let's look at those 3 most popular responses to the question of what law is and what it is not. Originally, when we started thinking about norms and principles that should be obeyed by all, we referred to some sort of a set of principle rules, usually originated by religion. As we progress, I will try to show you a map of contemporary outline of laws and the way we look at them. Historically, then, religion often fueled our understanding of laws, norms, and principles. Currently, we rather think about law as a form of a social contract. Our representatives, usually politicians, meet at designated spots. They are selected on our behalf, and they try to get a good understanding of what it is that we would, as a society, deem appropriate or inappropriate. With that, not everything that you guys perceive as appropriate or inappropriate is law. There is a certain threshold that needs to be met for an ethical norm, a moral principle to become law. And we trust our elected representatives in democratic countries to make that choice, to make an informed decision of a specific ethical moral norm to become the law and to be enforceable. With that, not everything that is right or wrong is punishable by law or is protected by a legal norm. In some countries, common law countries, law is amended, the content of law is amended or is adjusted by legal proceedings, by courts. So law is not just a law in the books, but it is also law in practice. This would usually not be the case in statutory law countries like the one I'm coming from, but in common law countries, the power of the judicial system is very close to that of politicians. So we would have those two streams telling us what it means to be legally binding. If we could progress to the further slide, Glenn, you could see a mechanism that in democratic countries we recognize as lawmaking. Usually we start off with the constitution, a document that is crucial for understanding where a country stands, what it finds is valuable, the basic principles that you would view as a country in need of legal protection. We operate in democracies based on the distribution of powers, checks and balances, the Montesquieu trias politica. So we have three branches of the system within a state. One is legislative, and that is the one that creates the law. Then we have the executive, that would be the one that makes sure that the law is implemented. And then we get the judicial, who stands guard for making sure that the law is applied in a just manner, that there is a coherent system. I'm using a graphic that refers to the US. I'm certain you know a similar reference in your own national legal system. So currently, when we speak about law, we speak about a very distinct set of norms that has been identified by our representatives, usually within the legislative, supported by the executive and the judicial. If we could move on to the next slide, Glenn, I would like to leave national law behind. If you look at national law, you start off with the Constitution, and then you move on to national acts of law. Usually the Constitution, whether written or not, is at the top of the hierarchy of sources of law. And then if we move on to the following slide, you will see that the national law is distributed across branches of law. You can see this on the following slide. I am certain Glenn will show that to us in a moment. So this would be a slide that represents different branches of law. Within each state, we try to organize those norms and principles, usually following the distinction between civil law and criminal law, and those administrative matters that deal with the construction of the state, if you will. Within each of those branches, you will see procedural norms. That's the boring stuff. That's the forms and the timetables that you have to meet. And you will see material regulations. For example, criminal law will tell you what a crime is, what kind of an action will be punishable by law. And this is interesting. I will refer to jurisdiction as we progress, but this is exactly where the decision on illegal content online, on hacking, on cracking is being made. So this criminal law essence is crucial to our understanding of what is allowed and disallowed online, or more broadly speaking, in internet governance. But this is just a very bird's eye view I wanted to use here. I would like us to move on from national law with this map that I had promised. You will see that national legal systems differ among themselves. Most countries are based on civil law. That would indeed be statutory law. We would need acts of law that tell us what is prohibited and what is allowed. Some countries, as already said, use the common law system where it is the judiciary that supports our understanding of what is allowed and what isn't allowed. Then you will see some systems that do refer to the religious component of each society, making sure that values reflected in religion are present in national legal system. So we differ between one another on how we perceive law, how we perceive norms, what are the binding principles we want to abide by. If we could move to the following slide, I would like to leave national law behind and try to look at the internet as an international network. If you look into international law, you will see on the following slide that it is quite different in its nature from what we just looked into, from national law. International law comprises of different sources, different levels of commitment coming from states. You will see, for example, the law of treaties that tells you that countries make certain commitments to one another. It is based on the principle of a binding commitment between the states, pacta sunt servanta, so we expect states to abide by their commitments. We will see commitments that refer to criminal law, but international criminal law is a very narrow category that deals with a very specified, narrow category of actions and individuals who could be called into court for having committed them. There's also discussion about international law in cyberspace or international internet law. Since we are looking at an international framework, would it make sense to apply international law to it? When we look at the origins of international law, if we move to the following slide, you will see that its sources are also quite different. What I often do with my students is I quiz them on who makes international law. We looked at national law. You can see that there is a very well-defined system, regardless of where you look in the world, that tells us what's legal and what is not. How does that work on the international level? Well, it's quite different. The pictures you can see here are supposed to represent 4 elements of how international law is made. On one hand, it states, and I have the lovely smiling face of President Trump here, just to represent a very strong, powerful state that not only interprets international law, but also very often tries to set the rules. Time permitting, we will move on and I will try to show you examples of how this actually happens in day-to-day business. I take this as we should move forward, so let's just do that. There are different sources of international law. However, you can see that it is also international courts, tribunals, and writers, distinguished writers we call them, which is the study of law that tells us how to best understand it. This is Niagara Falls, something close to Glenn's heart. This is also a state border. When we discuss online jurisdiction, a very simple case scenario is often used to best describe to the students the fundamental challenge that we face. Now, this fundamental challenge is referred to as transboundary jurisdiction, and it is represented by a simple case of a shot being fired across state border. That is a very picturesque state border that you can see here. We have US on one side, we have Canada on the other. You can imagine a very angry individual standing with a gun at one end of that bridge and firing a shot, causing harmful, deadly results in the jurisdiction of another country. Question is, who can assess the actions of that individual? Is it the country where he acted, where he committed that violent act, even though no harmful results were affected there? Or is it quite the other way around? Or is it the country where the bleeding dead body of his victim is lying that should have the jurisdiction? The answer is both. And as already said, that is a very simple example. We can make it more complex, but for the sake of clarity, I will refrain from doing so. So what you see, international jurisdiction implies that you have the right to assess also actions that happen outside state territory, as long as they cause harmful results within your jurisdiction, authority, or simply territory. If there is a dead body lying on the ground of your country, the culprit residing in a foreign state should still be held accountable to the action for his actions, even though he did nothing wrong within the jurisdiction where he's residing. I see a question coming from Kapil. Hi, Joanna. Which global regulatory bodies are responsible for the regulation of e-commerce, data protection, and internet access tariffs and charges? Also, what metrics, measures are needed to address legal issues in internet ecosystem? That is a wonderful question, Kapil. I'm hoping to be able to answer it more comprehensively as we progress. I will show you different examples. I wanted to start us off with something as hot and exciting as a dead body lying on the ground after being violently shot, and then we will move on to the internet and cyber attacks. But just to briefly answer that question, Kapil, there isn't one global regulatory body that does that. You could look at different international organizations. I will refer to the UN. I will also invite you to certain sessions within the ongoing ICANN meeting that will discuss this. But the brief answer, Kapil, is that there isn't one regulatory body that effectively deals with all internet issues. This is why we're looking at different scenarios. And Bill comments that there shouldn't be militia, whether they actually know that. However, I think I need more explanation on those comments going in the chat. So I'm just going to move on to the following slide, trying to link this violent murder across borders with a jurisdictional legal boring component to it. If we could progress, Glenn, that would be great. On the next slide, you can see something similar. Now, this is a cyber attack that likely escaped your attention, and I enjoy referring to it because it's an interesting example of how we think about internet governance, and as already advertised, I'm going to start us off with internet security. This is a lovely 75 Georgian woman. She lives in Georgia, as you can see, and she tries to improve her living conditions by collecting recyclable materials. On a lovely spring morning, she took off from her home trying to find materials that would be recyclable and she could use. She was very lucky that day because just very close to the surface of the earth, she was able to dig up a thick copper wire. She was very glad having done that because she could take that to the recycling plant and be offered quite satisfactory compensation. So without thinking a lot, she just dug out the copper wire, she packed it onto her little trolley, and she sold it for good money. The problem was that that copper wire was the only connection that Armenia had to the internet. This was a critical internet resource. This was the wire, if you will, that brought the internet to the entire country. I like to argue that this woman is the most successful cyber criminal ever because at a very cheap and quick rate, she was able to disable internet access to an entire country. The question is whether she should be held accountable, and if so, for which crime. She probably violated property of a company that offered those services. Whether we would expect that company to make sure that that copper wire was a little bit more secure than just basically lying on the ground is another question. What is more, what are the consequences of the international relations between Georgia and Armenia? One could argue that the lady might have committed a crime by stealing someone else's property, even though you could argue she had no idea what it was that she had just found on the ground. You could argue that there is a due diligence obligation on Georgia to make sure that its critical internet infrastructure is better secured. You could also argue that Armenia could be quite upset. Just like the culprit in the previous example, you can see a lady here causing significant transboundary harm, disabling access across Armenia for quite a few hours. So whether this very simple principle of transboundary jurisdiction applies here remains to be seen, remains to be answered. This dispute was settled amicably The Georgians said, well, okay, we should have taken better protection of that wire. They replaced it quite quickly, and the whole situation was resolved quickly, effectively, amicably. There was no reason for much more intense debate. But if we progress to my next example, you will see that around the very same time, there was a different incident that happened. I've put the word Stuxnet here in a red circle, as I believe that will tell you more. It's roughly the same time frame. And again, we're dealing with a harmful online activity that brought down, or at least significantly slowed down, the nuclear program within Iran. I'm certain you guys remember this case. So this is a case of Stuxnet, which is an online worm that was so harmful that it almost, and this almost is significant as that was an intended attack, almost set on fire a nuclear enrichment plant within Iran. The problem was that it was likely engineered by Israelis and the US. It was likely commissioned by the US government. And it probably, as you can read in detail in this New York Times article I'm referencing here, was done in collaboration with the company that offered its services to Iran in terms of building the nuclear enrichment facility. The question is whether there is anyone who should be held responsible for that specific attack. It's not critical internet infrastructures, but it is critical infrastructures. And this would likely, the Stuxnet attack, be the most famous contemporary attack that brings international law and international responsibility onto the agenda of politicians and technical experts alike. So we deal with a similar effect, transboundary harm, significant damage done online, in this case, through an engineered piece of malware. And the question, who and how should be held accountable? Unlike the case of the lovely Georgian woman, this case was not settled amicably. There were accusations coming from Iran in terms of an actual attack happening on their territory, on their security, safety. Clearly, neither Israel nor US confirmed that they were behind this attack. This brings us to an interesting argument of attribution. It is very difficult, challenging, if not impossible, to attribute responsibility here. If you look into the paper, into the article, you will see that these are basically journalistic allegations. It's difficult to prove that that specific piece of software was designed and created by a specific individual, and it will be even more difficult to prove that this was done based on order coming from a state military, for example. So this is a very harmful element of using malware online, a very harmful result we don't really have a good legal response to. The Stuxnet incident was probably the most significant recent attack. If you go to the following slide, Glenn, you will see the strategy that was used by the providers. I'm going to leave you with the slides. You're more than welcome to look into it. What's interesting about Stuxnet is that it was the human component that proved the weakest here, as is often the case. So the Stuxnet worm was distributed among different computers worldwide. You could have even had it on your device, but it remained completely harmless. It could have infected your computer and it would have not impacted its performance. It waited for its chance. And so it got one when one of the Iranian employees of the nuclear enrichment plant in Natanz brought his thumb drive, his USB stick, to work. Now that thumb drive was previously infected through the computer that guy had at home. He brought the infected USB stick to work, infected the entire plant, and caused it to almost blow up. Now let's keep in mind, had it blown up, we would have been facing the largest environmental disaster in contemporary times ever. In that sense, you could argue the link between the malware and the actual damage that happened. You could argue that it should have been Natanz that should have prepared its officers better. So this is an interesting case I would like you to think about whether there is a legal framework we could use here, and if so, what that would be. You can clearly see that there's a link between online malware and public safety. Let's move on, if I may. I have a few more fun examples. You guys might have seen also this lovely gentleman. On the following slide, you will see the somewhat concerned face of Gary McKinnon. Glenn, I'm not sure the slides are working. If we could move on to Gary, that would be great. Gary McKinnon has been a clever guy. He lives in Scotland with his mom, which is nothing to complain about, lovely. And he was very focused on aliens living on Earth. He had somewhat of, as you can see here, a medical condition. He had Asperger's, which made him very focused on pursuing a very specific agenda. That focus and that determination brought him to hack into the computers of NASA, FBI, CIA in the US in real time and steal terabytes of data. Again, could be considered your everyday usual criminal, or maybe just someone who has mental issues and should not be held accountable as per United Kingdom's law. The US viewed this as one of the most significant terrorist operations ever. At one point, it got to a very disputed situation where it was President Obama who insisted on Gary being extradited to the US and tried as a terrorist. You might imagine that his trial as a terrorist in the US would have been much more severe. The punishment would have been much more severe than would have been the case in the UK, in Europe, according to national and regional laws. So we look at situations like these just to give you a little bit of background with the variety of issues we deal with when it comes to online safety. I see Badria mentioning Estonia, and I actually have Estonia on the following slide, if we could just move on. So this is another lovely face. Konstantin Goloskokov is the man behind the Estonia attacks, if you will. Glenn, I'm seeing a blank slide. I don't know if it's just me. I can go on. I know what Konstantin looks like. It's not there he is. Brilliant. Thank you. So Konstantin Goloskokov, on the previous slide, I will get to cryptography as we move on. On the previous slide, Glenn, where we have Konstantin, you will see the guy behind the famous or infamous Estonia attacks. The whole problem evolved around the monument of the Red Army soldier you can see in the background. The authorities in Tallinn, Estonian capital, decided to move this monument from city center to the outskirts of Tallinn. You can see here the cemetery where the soldiers who lost their lives during Second World War were laid to rest. This monument was quite significant for Tallinn. It was an element of homage to Red Army soldiers who, according to narrative provided during the communist times, liberated Estonia. As the times changed and political narratives altered, the monument was moved to the outskirts of Tallinn. Many Russians, and Estonia enjoys a 30% Russian minority, felt that this was a disgrace. Among them was a young gentleman whose image you can see here on the slide. The pictures are referenced or copyrighted, if you will, in the little scriptures you can see here in the signatures you can see on the right of the slide. So you will see Konstantin getting very upset with what the Estonians have done, and he called upon his friends and colleagues in an NGO, a political organization, not a party, just a group of young individuals supportive of the Kremlin. He called among his colleagues to show civil disobedience. This civil disobedience brought down Estonian internet for, well, originally the report said it was a week. So for a week, the Estonians, very reliant on their internet infrastructure, they often use the term Estonia as a country that relies on internet connectivity, they were refrained from using online services. As already said, originally it was a week. The foreign minister of Estonia in 2007, as the attacks unfolded, said, well, this is war. We're dealing with cyber war. We need to have the NATO come and defend us. If you listen to that very same person who was the foreign minister then speak now, he will say, well, It was a few hours of slow traffic, so it was a minor disruption. A minor disruption, something that was officially named an act of cyber war in 2007, with the internet slowing down and refraining you to connect from certain services, now is being referred to as only something that should not have happened, but it wasn't that big. Originally, it was an act of war, and Estonia called for NATO's support to restore its economic capacity. So we look at different situations and we try to qualify and quantify these events. To those of you concerned or worried about Konstantin, he was never held to justice. He was never put in front of a court for navigating a major DDoS attack. That was the tool that was used. Russia called this civil disobedience. Russia prides itself on being a democratic country, and with that, it views civil disobedience as an element of that democracy. So Konstantin remained free from liability. Estonians were pretty upset, but never took any legal measures against Russia as of now. So you can see here different situations that deal with online security that change our perspective and how we think about the legal aspects of internet governance. If we can move on to the next slide, this is something that calls closer to home. I would presume it's just a few years back when, I hope you didn't, but you might have seen this screen on your computer. So this seems to be the newest reiteration of how online security is being perceived. You might have, which I hope was not the case, you might have seen this screen as instead of your desktop, instead of your files. This is cyber criminals trying to get money from you for decrypting your hard drive. We can move on to the next slide. You can see the headlines that referred to this likely most costly cyber attack in recent history. This is WannaCry. So again, malware, a piece of malware that was supposed to collect money from unaware users who were infected, whose devices were infected by that specific piece of malware. It was dramatic because in certain countries directly targeted by WannaCry, as you can see here, among them the UK, not only the financial impact was severe, but also you could clearly see here also direct threats to national health, to critical infrastructure, to critical services. If a hospital needs to cancel operations it had scheduled because it cannot access the computer system where it had data on patients, sensitive data on their health conditions, well, this hits at the very heart of every society. So we tend to look at cyber attacks right now as a crucial component of national security. The impact, the scale has changed. Just a piece of trivia, allegedly, again, referring to the challenges of attribution, WannaCry was designed by one of the authoritarian regimes to fuel its budget. So allegedly, all the cryptocurrency that was paid in to get your data back fueled one of the world's authoritarian regimes. Were there any consequences? We can't prove it to them. So other than political consequences, there is little that we can do. If we could move on, I'm just going to give you the last few examples that I think are interesting. This is a case of 2016, again, referring to critical infrastructures in Ukraine in the middle of winter. Another piece of software stopped a power plant, depriving large amounts of Ukrainians in the midst of a fierce Ukrainian winter from being able to provide heating to their houses. Another outrage, another problem. Allegedly, Russia was behind this attack. Again, no direct attribution, no sanctions, no legal redress. Let's move on. One of the favorite recent cases we have used to entertain participants of sessions like this one was the attack of the fridges. I'm sure you guys have seen this one. Internet of Things is a shorthand reference to all the devices that are connected online. A big issue for ICANN, a big issue when we speak about IPv6. So we are also now discussing 5G as an element to help us develop IoT. Those who work on cybersecurity have often mentioned that the IoT might be the weakest link for cybersecurity. They joked about the IPs of fridges being used to provide a cyber attack, and this indeed had happened. You can see the headline here: a massive DDoS attack on US soil was accommodated through the use of IP numbers that were connected to home devices. So that is another aspect to keep in mind. Let's move on. I want to link this discussion to the pandemic. We are now discussing very similar issues in the context of COVID-19. Because the global community is so reliant on the internet, any attack on the network that we rely on in our everyday life is perceived as a vital threat to the well-being of each country. So with that in mind, all of those lessons we have learned, or all of those challenges we have identified before, prove more pertinent, more significant when we enter the time of global reliance on the internet. There have been calls to use the internet in a peaceful way. I will refer to them as we move on. One other element that feeds into the COVID-19 crisis and our understanding of the legal challenges behind internet, its infrastructure and internet governance, is content, disinformation, if you will, or the use of data. On the following slide, I just wanted to put that on the table here. We talked a lot in the recent years about the way that data is being used. Cambridge Analytica was the code name for a misuse of data that is being collected by platforms, by certain service providers, and that data being used in a way that might not be in line with the original intentions of those who shared them. So this is another element of engineering certain actions, be it hardware attacks or simply be it disinformation that we might want to tackle. It was probably Cambridge Analytica and the events of last years that brought us to this interesting piece of proposal documentation. It's not a binding convention, as you can see. This is a document that was produced by Microsoft, of all the online actors, on the anniversary of the First World War, so the Paris Peace. The Paris Peace Accord was reinvented, if you will, with the Digital Geneva Convention to Protect Cyberspace. Out of all the actors, it was Microsoft who took the lead when it came to convincing states, private actors, but also individuals that cyberspace needs to be kept safe and peaceful. We have this concept in international law. There is a standing agreement on the non-military, hence peaceful use of outer space, of open sea, of the Antarctic, for example. So this is something that Microsoft leaned into and indicated that cyberspace should remain peaceful. What they also derived from, and I'm certain you guys know this, were the Geneva Conventions that dealt with humanitarian law. So how do we treat civil personnel? How do we treat individuals in times of war? The idea behind this very controversial convention was to keep the internet peaceful, to make sure it's not used for criminal activities. I wanted to do a case study. Let's see how this works. I will try to conclude with a simple yes or no. Yes, Glenn, I'm mindful of the time, but as already said, I want to leave some time for discussion, so I'll just entertain you with a few more cases, and then I'll try to wrap it up. Thank you. So the case study that I have prepared, and I'd love to hear back from you, is very simple. Imagine you work in a co-working space like this one. One of your colleagues hacks into your computer and steals the project you're working on. Would you, A, hack back, steal what he has taken from you and destroy all of his files? Or would you, B, report this? What do you guys think would be more appropriate? Do you hack back, steal the data back, and destroy his data just so that he knows you're not to be messed with? Or should you rather report the hack and try to have the police or the authorities take care of that. Bill, thank you. That's a B. That's a very legalist answer. Thank you. Does anyone think we should just hack back? Everyone's so obedient. Thank you, Angela. B again. Does anyone think we should hack back? No, because you're a legalist. Thank you very much. Not so much legalist as lazy. Yes, indeed, ladies and gentlemen. Thank you. One would argue that you kind of don't steal your bike back. You go to the police and you kind of inquire whether there's an option to get it back, even if you know where it is. I see a question from Kapil. Do we consider internet shutdowns, blackout as a legal measure to protect cyberspace or illegal means? State consider internet as fundamental right to express of speech. What is your take, Joanna? Kapil, I'm going to try and close this case, if you will, and I will use those 15 minutes to address the question of shutdowns, if that is okay. I hope that's okay. So let's just try and conclude on the hackbacks, and we will try to figure out internet shutdowns as well. So you guys rightfully indicated we shouldn't steal the bike back, we shouldn't hack back, which seems roughly correct. If we could move on to the next slide, Glenn, that would be great. We have cases in international law where this stealing your bike back practice proves challenging. I often use this case. Here you can see private companies, private military companies doing exactly that. Here we see them protecting cargo from being invaded by pirates. We used to think pirates were romantic. You can see Jack Sparrow here at the top of the slide. But now pirates go after private ships and they steal cargo. How do you protect yourself? Well, national companies, national police officers say, well, it's not our jurisdiction. We are not really inclined to protect your private interests. International organizations usually claim shortage of means to protect international maritime transportation. So what happens? You get a private company to protect you efficiently with guns like these ones. They basically just shoot potential culprits even before they approach the ship. Is this legal? Is this okay? Well, it's a gray zone. So you're not supposed to take active measures yourself. Private law protection is not something we are inclined to support, but those are interesting films you can see on YouTube. If we can move on to the next slide, this is also something you will see in US law right now. US companies are so disappointed with the way that the protection of online resources is going that they have actually, how should I say, lobbied or pushed for a bill, if we can go to the following slide, Glenn, that is waiting in the US Senate. It's been waiting there for quite some time. Active Cyber Defense Certainty Act. If you look at the acronym, it's lovely. It's ACDC Act, and that is no coincidence. So there is an act, a draft bill waiting in US Congress to allow active cyber defense by private actors. If you know that your colleague from the office is stealing data from you, you can basically hack back. Is this okay? Is this how we should be settling our differences? US has the concept of defending forward, preventive cyber security, self-defense, if you will. That is a very controversial notion. If we could move on to the last two slides, Glenn, I will try to answer Kapil's question and wrap things up. If you look at the cyber attacks happening in the world, US has a right to be quite upset and disappointed because most of the attacks would fall onto their businesses and infrastructure. Another area that is particularly vulnerable is Europe. If we could move on to the following slide, and I will conclude here, and I will not go into cybercrime, you will see that Europe has taken quite a different approach. Here we look at cybersecurity as an element of commerce of our digital market. I've highlighted different legal acts that were approved, but making it a long story short, the focus in Europe is on resilience. We try to make sure that our infrastructures are as safe, as secure as only possible. There is a discussion of cybersecurity due diligence that's going on here in Europe. There are two different approaches, as you can see, to the ongoing cyber threats. One is active, that would be the ACDC Act, if you will, go and steal your bike back. And the other one puts emphasis on resilience. Make sure that your fence is high enough for your bike not to get stolen. So on where we stand in terms of cybersecurity protecting infrastructures, I will go back to Kapil's question, but I'm also looking forward to your question. We have questions. We just have 15 minutes. Let's just see how interactive we can make this. We can go to the last slide, Glenn, as that has a thank you, and the pre-last one has questions on it. So I think we're safe to move directly there to the very last slide, and I will let you scroll through these and try to answer the question. So let's read it out again. Do we consider internet shutdowns as a legal measure to protect cyberspace or illegal means? States consider internet as fundamental right to express free speech. Now, the answer to your question, Kapil, very significantly depends on who you're going to ask. We have a framework of human rights law that clearly views freedom of expression as a human right. It also clearly views freedom of expression as a conditional or limited, if you will, human right. So you are free to speak your mind as long as you are respectful of others' rights and interests. The states that do impose internet shutdowns focus on the need to protect public security, to protect public interests. The question of balancing the two, of balancing public security and freedom of expression, or what I also like to mention in the context of internet shutdowns, the right to assembly. Just as we are assembling here, there are others assembling online, often for political reasons. So should the internet be a safe haven for free expression? The question is, to what extent? Which litmus paper we should be using to test whether this is still free expression or whether it is a threat to security, whether it is hate speech, whether it is offensive or it infringes someone else's rights. So again, Kapil, I'm going to say it depends on who you're going to ask. There is a human right to free speech. We would be even inclined as the international community to view the internet as a precondition to enjoy your freedom of expression. But it is not an ultimate, it is not an unconditional right. You can exercise your free expression up to a certain level. That level is often designated by national laws that differ tremendously, as I was trying to say at the very beginning of this presentation. I hope that answers your question. I'm happy to offer more insights. I'm going to the slide. Glenn, I know you've been monitoring the chat. Is there any specific question I'm using here or a comment that we should address?
Yeah, I believe Bill asked a question. Bill, can you get audio?
I don't think I did. Sorry.
Oh, okay. So, I have you unmuted if you wanted to ask something.
I see a comment from Bill. I'm happy to read it, or if you want to share it, Bill, that would also be fine, however you want to do it.
Yeah, I can just share it. Basically, whether you're in the cyber world or anywhere else, if somebody's having to take private action to enforce the law, then what that says is the official law enforcement has broken down or not been built or something along those lines. It doesn't really matter whether it's in the cyber realm or anywhere else. The people who are enthused about that are generally reluctant to admit that that's what they're saying, but that really is what it comes down to. Thank you.
Thank you, Bill. I would be inclined to agree with that in the context of ICANN and ICANN policy making, if you will. I'm going to stay a link into the chat. I hope that works. I know you guys are following ICANN meetings. I know you know that there is an ICANN meeting going on right now. In terms of this fine line between law enforcement, especially when it comes to criminal law enforcement, and the private sector taking initiative, We are planning for what I perceive to be an interesting session tomorrow, if you guys can join us around the same time. It's 14:30 UTC. That will look into what ICANN community refers to as DNS abuse, and I encourage you to look into the definition of DNS abuse and existing ongoing cybercrime treaties, investigations, collaborations. I'm very excited to have Alexander Zeger, who heads for the Council of Europe the cybersecurity section. He's the head of the Budapest Convention, if you will, the face and the head of the Budapest Convention. He will be joining us tomorrow, and I'm very excited to hear from him on how he perceives this crisis, if you will. There's a challenge we're facing with law enforcement not really being able to keep up with all the challenges that are posed by the online community that Bill so rightfully noted. Question from Rudolph. But how well does the existing UN decision of, no, it's not, it's UN Declaration of Human Rights encompass digital rights? Oh, Rudolph, I would say it does so perfectly. So we have consensus from the international community, and I'm happy to refer you to the declaration, the resolution from the UN Human Rights Committee that emphasizes that human rights offline are applicable online, that international law offline is applicable online. So whatever we have in the offline world should be reflected, needs to be reflected, must be reflected online. The only question that causes us somewhat of a dismay is, how do we do that? So the declaration applies perfectly, one-to-one, if you will. The practical issue is, how do we make it work? So who makes the call on, for example, limits of freedom of expression, for example, privacy, for example, right to assembly? So the principles are quite clear. It's the day-to-day work that gives us somewhat of headache. I'm curious if we have any more questions or if we have any more comments. I was actually excited to hear from you guys on how you perceive legal aspects of internet governance. I've been going around these issues for quite some time. I feel like I'm not most legitimized to start a conversation because I feel I have too many my own convictions. So I was kind of hoping to get some feedback from you, fresh minds going into the IG sphere and having a very strong IG background, because law seems to be giving us, as already said, somewhat of a challenge. Glenn, I'm glad to stop here. We have a few more moments. I know you wanted to make some concluding remarks. I'm happy to blabber on. As you can see, I can just go on.
I do. I'm going to ask Kapel to make a couple of comments. I just unmuted him.
Okay, go ahead.
Okay, Kapel. Yeah, Kapel, I unmuted you. Go ahead. Yeah, I just made him a moderator. To this is an interesting tool. This is not as good as Zoom, but it's built in within Moodle. So I do apologize for some of the challenges we have. So Kapel, one more time. Okay, I see Amir has typed in something. It seems tricky. We need to define a line where the sovereignty of a country starts and the international law can be enforced. Now, that's a really good comment on that gray area that makes it challenging. Do you have any comments on that, Joanna?
Yes, I think it hits the nail on the head, so to speak. There are actually intense discussions, and I'm happy to give you details on the countries that are discussing this, on this fine line between sovereignty and a sense of international community, if you will. There are some states that look at sovereignty very restrictively. Whatever is within my territory and deals with my people is my business, and you have nothing to say about it. That is the Westphalian concept of sovereignty, if you will. So in the Treaty of Westphalia, states agreed to more or less this exactly. So whoever is dealing with a certain territory, whoever rules it gets to decide what happens. But we have progressed a little bit in the last 100 plus years. So we tend to look at sovereignty as something more flexible. We tend to say that sovereignty ends where international law begins. And if you want to be a member, a valuable, an active member of the international community, which is pragmatically non-negotiable in 2020, you need to make certain commitments and you need to be a team player. The question of what that means is being disputed. There's a whole body of work that's being done on, well, basically in all countries of the world, but Europe has taken on an initiative that's called the Cyber Diplomacy Toolbox, which focuses exactly on this negotiating power of the states, trying to look into international law and the concepts such as you mentioned here, sovereignty and jurisdiction, when we try to deal with those online challenges. So I fully agree. It comes down to individual states willing to be team players. But it's interesting because we're talking about internet governance. And in internet governance, it's not just the states who are actors, right? We have platforms, we have service providers. You could see the Digital Geneva Convention coming from Microsoft, to the dismay of countries who said, well, of course, Microsoft is not legitimized to propose any kind of a convention. What are you guys doing? During the ICANN meeting that's now going on, we will have within the at-large community, proposed by the at-large community, a long discussion on platforms and the power that they hold in 2020 and beyond. So that is also something to consider. National sovereignty is one thing, and the power of platforms seems to be a competing concept we also might want to look into. I see a comment from Kapil, sustainability issues to balance digital sovereignty and freedom of expression, sometimes difficult for states to manage and address concerns of individual companies and regulators. You're right on, Kapil, that is a very correct observation. Please kindly note it's not just freedom of expression. Europe feels very strongly about data protection, whereas, for example, the concept of privacy in South Korea would be very different than that from Europe. India recently introduced a comprehensive data protection and privacy regulation, and you could argue that it is still a very surveilled state. So in that sense, Glenn, into your hands to wrap up. Thank you, guys. I've really enjoyed it. Thank you for bearing with me.
Great, Joanna. I think we could go on for another hour for sure, Joanna. We'll have to circle the wagon on this, but you are a member of the school. Do jump into the chat and some of the resources. I wasn't aware of that U.S. law, so any links to the development of that, we'll try to make sure we add to our complementary resources. Joanna was gracious enough to review our content back with Bill on giving feedback and quality improvement during our beta period. So Joanna has been aware of what we're doing, and we feel very fortunate to have Joanna in part of our first Group A cohort group. So I really appreciate it. And on behalf of everyone here today, I'd like to express our appreciation of your time, your professionalism, and your dedication to your craft. So again, thank you so much, Joanna. I just want to remind everyone that we have 3 more sessions that will be coming up the next few weeks, and then we'll please complete your quizzes and print your certificate. We'll be having a special Zoom, not this, but a Zoom session coming up with a special speaker. Avridori will be talking about internet governance. As at the beginning, you may have missed it, but before we started recording, we mentioned that Joanna will be doing 5 sessions, not 1, not 2, but 5 sessions at the IGF coming up. And so we'll be sharing those sessions for you as well. So please bear in mind, if you're interested in participating with the IGF, you can actually do it remotely. So in conclusion, again, thank you all for coming today, and we'll see you online. Thanks again. Bye-bye.
Thanks again, everyone. Bye.